item on the open session of the REC meeting. This is the NESA REC meeting number 358, held today, the 18th of September. We've got one item for the open session, and that item is an application from Stormcrow 10 CC application for the first amendment of the license conditions issued for the operation of a storage facility located at number 5 Hagen Street, Jet Park, Gauteng, and it relates to a license issued in 2013. On that note, members, can I get an indication that we adopt the agenda as presented for the open session? Thank you, Ms. Masetti. I do support. Thank you, Mr. Mkhize, and thank you, Mr. Gumede. On that note, we will move on to the item, which is under petroleum pipeline regulations. Ms. Mtwa, please do take the item as having read and give us the highlights on what needs to be brought to the attention of the committee and allow members much time to debate on the item. Thanks. Over to you, Ms. Mtwa.
Thank you, Chair. Good morning, members, and good morning, colleagues. This item will be presented by Mr. Ngwako Ntwane, who is one of our intent. He has requested to introduce the item. I'll hand over to him. Mr. Ntwane, please come in.
Good morning, colleagues, and thank you, Chairperson. The purpose of this submission is to request the Regulator Executive Committee to consider and approve the first amendment of the conditions of the license issued to Stormcrow for the operation of its storage facility located at 5 Hagen Street, Jet Park in the Gauteng province, to include 2 new underground storage tanks, each with a design capacity of 83 meters cube, for the storage of 95-octane unleaded petrol. And the decision and the reasons for decision document attached here to as Annexure A, and the amendment addendum attached here to as Annexure 1 of the decision and the reasons for decision document. During the site inspection of Stormcrow storage facility by NESA compliance team on the 8th of March 2023, Stormcrow stated that the facility has not been operational since August 2022 for the purpose of refurbishment, with the 2 new underground storage tanks being installed during November 2022 as part of a refurbishment project without a license issued by NESA. Furthermore, Stormcrow stated that it was of the view that it did not need a license due to its facility being below the bulk threshold of 1,500 meters cube. Stormcrow was advised to continue complying because NESA has not revoked the below bulk licenses through the High Court. Hence, the application was submitted on the 11th of May 2023. Stormcrow has started to comply with all other regulatory requirements thereafter. And it is recommended that the Regulator Executive Committee considers and approves the first amendment of the conditions of the license issued to Stormcrow for the operation of its storage facility, and approve the decision and the reasons for decision document attached here to as Annexure A, and the amendment addendum attached here to as Annexure 1 of the decision and the reasons for decision document. Thank you.
Thank you, Dr. Ntwane. Members, there's a presentation before you. Are there any questions or issues of clarity in relation to this particular application? I see your hand is up. Ms. Masetti, you may come in.
Thank you, Chairperson. Chairperson, I have 2 main questions. The first one is to find out if the team has issued a notice of non-compliance, or whether this is something that they do when they conduct inspections, send or leave a letter showing that they have not complied, with the conditions of license or with the provisions of the Act. if I may just find out if that is part of the process that they follow when they discover non-compliance, so that this is not by negotiation, as the regulator is not supposed to be negotiating with the licensees in instances where licensees have breached license conditions, or if they have violated the provisions of the Act, just to find out what action they have taken, if that action relates to something in writing that they leave there to indicate that there was no compliance. The second thing, Chairperson, that I would like to find out is the seeding of the legal requirements or legal obligations of this of Stormcom Crow, by indicating that there is another third party that operates its storage facilities. I would like to find out if something like that is allowed in the Petroleum Pipelines Act, that another party can now assume the obligations of operating facilities when these facilities are actually licensed to Stormcrow. And I see that in the submission, we have said nothing about the fact that Stormcrow, as the licensee, that is given the rights to operate. Now it indicates that those rights, it has ceded them to another party. We are not saying anything about that. I would like to find out if something like that is allowed, and how do we deal with it? And also, to the extent that Stormcrow is going to utilize these facilities and they are users of these facilities, surely there will be a cost by ceding those responsibilities to somebody else. That person will charge for that, and therefore those costs will have to be paid by the users of these facilities where the petroleum products are stored. So I would like to find out how that has been considered as an implication of ceding such responsibilities. The third question that I would like to find out, Chairperson, is it relates to page 6, table 5, where the team indicates that it does not know where these storage facilities are connected to, whether there's pipelines close by or whatnot. I'm really not, I'm taken aback by that, because surely they should know where they have issued licenses, the location of the licenses and for storage or pipelines and so forth. They should know where they are located. The GPS and other licensing data should be telling them, so that they know what infrastructure is adjacent to these facilities. Otherwise, then it becomes incomplete as to how the storage tanks are supposed to operate, what feeds into these storage tanks in terms of the products that are stored therein. That is the third question, Chairperson. Thank you very much.
Thank you, Ms. Masetti. Mr. Committee?
Thank you, Chairperson. Good morning to members, to you and members. Just one question for me. Page 5 of 24. I just wanted to get a question of clarity. Paragraph 8. Is that 1,500 cubes or is it 1,500 liters? I guess I'm asking whether it's 1,500 liters or is 1.5 million liters. Is that our definition of bulk? Maybe I just assumed that it was linked to the definition of bulk by the in terms of the Petroleum Products Act, which is 1,500 liters. If I can just be clarified, thanks.
Thank you, Mr. Committee. I think my question has been covered by Ms. Masetti. It relates to not ceding its leasing to a third party as well, in terms of whether do our license conditions have such a provisions. I think she mentioned that which will be based on the Act. She asked if the Act does have this, and as well as if there is such a provision, is the licensee allowed to do it without consulting the regulator? I think I'm just adding on to that because that's the question that I had. And having noted that the licensee said that they couldn't comply with the license conditions because of the fact that it was leased, and the other reason stated was they are using the bulk determination decision that we took in 2016. So if the team can just assist in clarifying that. Over to you, Ms. Mtwa. I think you can guide who's going to assist Mr. Ntswane in responding to the questions. Thanks. Oh, I see Martin's hand is up. Martin, over to you. You've got about 2 to 3 minutes to respond. Thank you.
Thank you, CEO, and good morning, members. I want to deal with the first question and then Mr. Riba to assist on the compliance part. Through you, Chair, Mr. Gumeri, it is 1,500 cubic meters is the bulk determination threshold, or then 1.5 million liters. It is not linked to the Products Act quantum, which is part of the confusion that's out there. So it's definitely 1.5 million liters and not 1,500. Mr. Riba, in terms of the other questions, but maybe just one introductory comment about the ceding of the legal obligations. There are several such cases where operators, state-owned companies also, where they do that, but it has to be done. It has to be notified to the regulator, as in terms of your question, CEO. It's not a matter that they can just do it. So as part of the application and as part of the reporting, there is a requirement to do that. Maybe Mr. Riba, in terms of Ms. Maseti's question on the non-compliance, and then we'll take the others.
Yeah, thanks. Good morning, members and colleagues. In terms of compliance, yes, we are guided by the approved compliance procedure, which says we need to remind the licensees via email, I think 3 times, and then followed up by letters before we issue a notice of non-compliance. But before we issue a notice of non-compliance, the submission has to come to the PPS first for such notices to be handed out. But in this case, we went to visit. It was prior to us reaching that stage of issuing the notice, and we met the owner of the facility, who actually said to us that, look, he's not running the facility itself. I mean, it's being managed by this list out operator ever since he bought it, and he was not really hands-on on it, and indicated that he's willing to comply. He was not really aware about most of these things, that the requirements, and they eventually also hired a consultant afterwards to assist them with this, just to show that they are really willing to comply, because he said he was not really hands-on. But we were in the process really of going to issue that notice, guided by the procedure, Ms. Maseti. And then on the issue about not knowing where the facility, we do state that it is far from the pipeline connected facilities. These are the places where it can source fuel. We mentioned the depots around, which are closer to Jet Park. Those are the only possible places they can source, rather than the pipeline. We stated Sasol Refinery, Langlaagte, Waterloo, Natref. Yeah, so that's just to indicate what other major facilities are there around and their distances from that facility, and that it's not really close to the pipeline itself, and it's so small that it can really support the volume that comes through the pipeline. in terms of the throughput. Those small facilities, they can't handle such high volumes that comes through the pipeline. So hence they're not connected to it. It was just to indicate the possible sources. And we don't know who the operator will be, because they're still in the process of appointing that operator. And that operator has a wholesale license. And we don't know who that operator is contracted to, or which source of fuel they'll be using. That's what we're trying to say, ma'am. Thanks.
Thank you, Mr. Riba. Mr. Mkiza.
Thanks, Jefferson. And thanks for the responses and questions. But Mr. Riba, I remain of the view that we should, especially in the submission itself, indicate our, I would say, concern or misgiving around the issue of having to visiting this licensee, and then the fact that in just for transparency, in my comment to the team, I'd even indicated my misgivings around the way the act is currently, that it will become more like rubber stamping, so to say, or just watch when something has been done wrong, and we actually cannot. It's more like they get away with impunity, if truth be told, which then for me it's a concern. Yes, we appreciate the fact that they are rectifying or remedying the situation, but one would appreciate if the act was more stringent in this regard, and it's one of those things that we are still pending the amendment of legislation for us really to see them at least being considered, if not actually being sustained through to the amending of the act accordingly. And then two, with the issue of operation, I think it must be clearly articulated that someone may operate like you would employ, so they can have an agency agreement with a person to operate. Really, when it comes to operation, in any event, if you don't have people employed, you can have another entity that has got an agency agreement with you, which cannot be precluded by legislation. But I think that it should also come out very clear that in that instance, one is liable for whatever, or takes full responsibility and accountability for the operation of that facility. So pleading that one was not aware or pleading ignorance is not an excuse. It should just also be articulated clearly there. And then lastly, on the issue of not being pipeline connected, I think if you can just indicate that especially under 20, when you talk market considerations, where you're saying that furthermore the storage facility is not pipeline connected, but it's fed via road transport, just to make that one clear, and could source its product, then you put that it being likely dependent, or you can say it may source its product from the refineries or other pipeline connected storage facilities. If you can just put it like that, so that it shows that you know, as you visited the site, the site. It's not like you are just speculating. That speculation is actually not necessarily speculation, but it's just to give an understanding that there are these options based on what you went there and saw for yourself, instead of casting doubt into the mind of the reader. Thank you.
Thanks very much, Mr. Mkiza, for that input. Ms. Masetti?
Thank you, Chairperson. A quick one. Chairperson, on paragraph 9 of the covering submission, there is a company there. It's confidential, the name there, that the applicant here has appointed. Maybe they can just clarify if that is the one that will operate, or there's another one that will be appointed, because they indicated that they have appointed that company on paragraph 9. But also, Chairperson, for purposes of clarifying the issue of asking another third party, they have not dealt with it. I think that's my point, Chair. They have not dealt with it in the analysis, whether this is something that is allowed in terms of the Act, and to bring it into the scheme of the Act. What is it that needs to be done from our side? Remember that in Section 15. The applicant, in terms of the facilities that they require license for, they are always asked to demonstrate technical ability, financial ability, as well as administrative ability. So within that context, to the extent that Storm Crow is not able to operate these facilities, then it will indicate why did it appoint a particular company in terms of the expertise of that company to then fulfill the technical abilities that are stipulated in Section 15. And that's how the team is supposed to bring in that element. And it is not addressed at all. They just silent. All that they mention is that they had somebody else who will do this for them. So that is the issue here, Chairperson, that I am raising, so that they bring the context to it. And also the issue of operations, it goes with safety, it goes with expertise. And when you are financed, that gets taken into consideration. Maybe within that context, that's how they can explain this. But I don't know exactly what is the situation in their case. Thank you, Chair.
Thank you, Ms. Masetti. Martin, do you want to come and...
Yeah, thank you, CEO. Noted, Ms. Masetti, and maybe it was an oversight, because we've got from the 180 facilities, we've got a very large portion where this model has been adopted. But definitely we can and should have improved the analysis and stated as you indicated. And then to answer your question, I did put it in the chat box. The company listed there in paragraph 9 is the consultant that will be assisting the licensee to make sure, like Mr. Mkhize said, ignorance is not an excuse, to make sure that all the compliance issues are duly or properly dealt with. The party that will be operating to that contract was not signed yet, still need to be confirmed, but it's a different party, which is in fact a wholesaler licensed by the Department of Energy that will be doing the actual operations. I'm not sure if I've covered the question, ma'am.
Mm-hmm. I see Mr. Mkhize's hand is up. Mr. Mkhize?
Yes, thanks, Chairperson. I think the way of enhancement is just to indicate that the law does not preclude it as it stands in terms of having a separate appointing an operator or outsourcing the actual operation of a facility, but that the entity involved remains responsible and accountable in its own name. I think if there's that kind of an enhancement that is then provided, also including the fact that, as I said, they don't transfer any liability of any sort or responsibility or even accountability. They are the ones that must answer, and this is what all the other licenses that have got similar agency agreements do. The other one is just a representative in terms of the application and communication when it comes to engaging with the regulator, which is also operating for one or two other clients in this regard, just to make sure that when we engage with them, they are the mandated representatives. They are not just representing their own selves or their jackets. So I think that should be enhanced in line with what I've just said. Thank you.
Thank you, Ms. Msiti. I hope you are covered on the issue of listening to third parties. Thank you. On that note, then members, I don't see any other hand. May I then request that we go to recommendations? They are on paragraph 34 on page 9 of the submission cover. And I would also want to request the team to note the enhancements area, because the recommendations that are made under paragraph 34 are for the REC to consider and approve the first amendment of the license condition issued to Stormcrow for the operation of its storage facility located on 5 Hagen Street, Jetpack, Gauteng Province, to include 2 underground storage tanks, each with a design capacity of 83 cubic meter for the storage of 95 octane unleaded petrol. And secondly, to consider and approve the decision and reasons for decision document attached as Annexure A. And lastly, to consider and approve the amendment addendum attached as Annexure 1 of the decision and reasons for decision document. I think lastly, to enhance the paragraph dealing with the connectivity of the facility, I think it was paragraph 20, and as well as to enhance the sections in relation to a licensee leasing its facility to a third party to be, those are the 2 enhancements that are requested. Members, can I get an indication of by hand whether you support the recommendation and including the 2 enhancements that have been mentioned? Thank you, Ms. Maseti. Thank you, Mr. Mkize, and thank you, Mr. Kumeta. I also support the recommendation. On that note, members, we have come to the end of our open session of our meeting of today, and I would like to thank members of management, and as well as the stakeholders that have joined us on various platforms. Thank you so much, and the meeting is